Hey everybody, the last time we got together I said I was going to try to get back to a normal schedule. And sometimes you make plans and then your plans get thwarted. And for the last 2 years my plans have been thwarted by the governor because every Friday afternoon she was issuing a new executive order that had to do with COVID. This time we can't blame the governor. This time we're going to blame the Court of Claims, the Michigan Court of Claims. Because last night the Michigan Court of Claims issued an opinion and order in a case called Mothering Justice et al. Versus Dana Nessel, Attorney General and the state of Michigan. And you are asking me, Steve, why do we care about Mothering Justice et al. Versus Dana Nessel in the state of Michigan? And we care because the opinion and order deals with two employment laws that were enacted by the legislature back in 2018. So think back to 2018. In 2018, we're coming up on a general election. And during that general election, there were two ballot initiatives. One was called the Improved Workforce Opportunity Act, which dealt with the minimum wage. And one was called the Earned Sick Time Act, which provided earned sick time to employees, paid sick time to employees in the state of Michigan. Now, Michigan is a weird bird. We know that already. Anybody who lives in Michigan knows that already. It is a weird state. Michigan has a provision in its constitution. I'm going to be looking down a little here, guys, because I haven't memorized this, so I'm going to have to read a little. And I'm not a constitutional lawyer, but Michigan has a provision in its constitution that allows the people of the state of Michigan to enact their own laws. It's called an initiative, and it's contained in Article 2, Section 9 of the 1963 Michigan Constitution, the Constitution that was ratified by the people in 1963. That wasn't that long ago. I was around then. I really was. I was 3 years old. So here's what the Constitution says, and let me read just a little bit. It says the people reserve to themselves the power to propose laws and to enact and reject laws called the initiative, and the power to approve or reject laws enacted by the legislature called the referendum. So that's line 1 of that article. And it says, if you people want to make a law, you can get signatures and put it on the ballot and vote on it, and you can make a law. It doesn't have to be the legislature. And if the legislature does something you don't like, within limits, like there's some budget limits and stuff like that where you can't mess with it, you can get a petition, get some signatures, get it on the ballot, and overturn the law that the legislature just passed because you don't like it. Now, to invoke the initiative or referendum, petitions have to be signed by a number of registered electors, that's voters, registered voters, not less than 8% for the initiative, and 5% for the referendum of the total vote cast for all candidates for governor in the last election in which the governor ran. So we take all the people that voted in the last gubernatorial election, we count them up. If you've got 8% of those number and signatures for your initiative, you're in. 5% for your referendum, you're in. Okay, now, that's not the end of it. It doesn't just go on the ballot, as you know, or we wouldn't be talking about this. If something is set up to go on the ballot and it's certified and it's taken to the legislature, because that's the way the process works, the legislature has some options. And they really, according to the court, they have 3 options according to the Constitution. Any law proposed by initiative shall either be enacted or rejected by the legislature without change or amendment within 40 session days from the time such petition is received by the legislature. Okay? Enacted or rejected without change or amendment. So I can enact the law. If I like it and say, hey, we don't need this to go to vote, we'll just enact it. The legislature can enact it. Or they can reject it, which means it goes on to the ballot. It doesn't get overturned or anything. It goes on and we vote about it. Or there's a third option. The legislature, if they don't like the law but they don't want to reject it, they can write their own law covering the same subject matter, and then it goes on the ballot right next to the law, and the voters decide, and whichever one gets the most votes, that's the law. Now, there's some other key provisions to this thing. No law initiated or adopted by the people shall be subject to the veto power of the governor. So, if you let this thing go to the ballot, and the people vote on it, and it passes, the governor can't veto it. And and most importantly for the legislature here back in 2018, if it's passed by the people, then the legislature can only amend it or modify it in any way with a supermajority. 3/4 of the members elected to and serving in each house of the legislature must vote for the change of the amendment. So back in 2018, we had these two things going on the ballot. They did is they passed the Improved Workforce Opportunity Act and the Earned Sick Time Act without change or modification. And then they went on Christmas break, and then they came back, and then they amended the laws by simple majority, and then Governor Snyder signed the law, and voila, we have what we have today. We have the Paid Medical Leave Act, and we have the Workforce Opportunity Act, all right? Now, judge, in this case, looked at the issue. He said, the question before the court is whether the adopt and amend strategy that the legislature employed to enact, and in the same legislative session, and that's important, substantially amend two voter-initiated laws violated Article 2, Section 9 of Michigan's 1963 Constitution. Each party has moved for summary disposition. And then the judge does a long constitutional analysis covering three main headings. And he comes to the conclusion that the adopt and amend strategy does violate the Constitution. And he relies on the language of the Constitution itself, the language of Article 2, Section 9. He reads that language and says, this prohibits the legislature from doing what it wanted to do. Then he looks at the history, and he says the history, the legislative sessions when they were writing the Constitution, the Constitutional Convention sessions, and the things that they said to the people when they tried to get the people to vote on the Constitution, that supported that this was unconstitutional. And then he looked at case law, and he looked at a case primarily called Farm Bureau to say that Farm Bureau already says you can't do that. There's a Michigan Supreme Court case that says you can't do that. And I've got two Attorney General opinions I need to consider. One is 55 years old and was written right about the time the Constitution was ratified by then Attorney General Frank Kelly, and the other is brand new, written by then Attorney General Bill Schuette, who told this legislature that they could do exactly what they were doing. And the court said, based on the case law and the Attorney General's opinions, although he didn't rely on those, but relying on those, we find that it's unconstitutional for the legislature to do what they're going to do. The court made a point of pointing out the differences, the significant amendments to these two statutes, and that was important to the court. The court said, for example, 2018 PA 368, which amended the Improved Workforce Opportunity Act, reduced the increase on the minimum wage from $12 per hour to $10.10 per hour, removed the annual adjustment after 2022 based on inflation, and eliminated language specific to tipped employees. And with respect to the Earned Sick Time Act, as for PA 218-369, the new law, which amended the Earned Sick Time Act and renamed it the Paid Medical Leave Act, exempted employers with fewer than 50 employees, lowered the minimum number of hours that could be used in a year to 40, and repealed the section prohibiting employers from taking retaliatory personnel actions against employees. And then the judge says this: the new laws, therefore, substantially amended the original laws proposed by the voters. The process effectively thwarted the intent of the people and denied them the opportunity to vote on whether they preferred the voter-initiated proposal or the legislature's suggested modification. And the judge said this: therefore, in line with the language of the constitutional provision, the history, spirit of the Michigan Constitution, and the Supreme Court's decision in Farm Bureau and its progeny, the court concludes that the adopt and amend process the legislature used to enact 2018 PA 368 and 2018 PA 369 violates Article 2, Section 9 of the Michigan Constitution. What the legislature did, according to the judge, was unconstitutional. So what does that mean? Well, let's take a look at what the judge ordered. The judge ordered, he granted summary judgment to the plaintiffs and denied the Attorney General's summary judgment. He ordered the state's motion for summary disposition be denied, and then he ordered the following: that 2018 PA 368 and 2018 PA 369, the law that we currently are living with today, the two laws that we currently are living with today, are voided. And the initiatives adopted by the legislature as 2018 PA 337 and 338 remain in effect. So in other words, the judge said, you guys were trying to pull a fast one. I'm not going to let you pull a fast one. In fact, I'm going to tell you that when you adopted these two statutes without change or amendment or modification, those two statutes are now the law. Whoa. What does that mean? Well, we don't really know. Okay, if you read the newspaper, everybody is saying, don't worry, this is going to be appealed, this is going to be appealed, this is going to be appealed. I'm not so sure. Here's why I'm not so sure. Dana Nessel is one of the named defendants. The Attorney General is one of the named defendants. The Attorney General put a statement out today congratulating the court on making the right decision and praising the court's decision. Doesn't seem like she's got a lot of incentive to appeal. Now, in fairness, there were two Attorney General, groups of Attorney General in this case, one on each side of the case. It's a weird thing about how this case works, because the Attorney General's got to represent the state, and the state was a defendant. But the Attorney General was also representing the citizens, and anyway, it's weird. Don't forget that when all this was done, Dana Nessel wasn't the Attorney General. Bill Schuette was. He's not there anymore. She is. The governor, the state, is certainly not going to appeal. She's applauded the decision, too, as a victory for workers in the state of Michigan. And the legislature, who has every incentive to appeal, can't appeal because they're, in my opinion, again, I'm not a constitutional lawyer, they're not a party to the lawsuit. They've already said they're not a party to the lawsuit. They tried to intervene in the lawsuit, and the judge said, no, you can't intervene. So where does that leave us? Well, we don't know. According to an article I read earlier today, the Michigan Department of Labor and Economic Opportunity, which this article calls LEO, hasn't indicated what they're going to do about this, and they're the people that are going to enforce this thing. According to the article that I read, the regulatory agency, quote, is reviewing the judge's decision to determine next steps and ensure the state is in compliance with the law, end quote. And according to a spokesperson, they're, quote, committed to making sure that workers and families have access to the pay and benefits that they deserve, period, end quote. So, do you have to start complying with these laws right now? We don't know. You're not going to be able to anyway. I mean, maybe the minimum wage one you could, unless you're a restaurant, because you just lost your tip credit that you've been taking for years and years and years. But the real hard one is going to be the Earned Sick Time Act, right? Because that's significantly different than what we have right now, which is paid medical leave act. So let me just take a couple of minutes to talk about that. And then we'll talk about what we're going to do next. Okay, so we have the Earned Sick Time Act, which is what was on the ballot and what, according to this judge, is now in effect as law in the state of Michigan. And we have the Paid Medical Leave Act, which is what the legislature passed and what we've been living with for the last year, 2 years, and 3 years, and is now void, according to the judge. Paid Medical Leave Act applies to who? Employers with 50 or more employees. Earned Sick Time Act applies to who? Any employer with 1 or more employees. Earned Sick Time Act differentiates between small employers and large employers. But a small employer is defined as anybody with less than 10 employees. And a large employer is an employer with 10 or more employees who are employed on the payroll for 20 or more work weeks. That doesn't seem like a very large employer to me. What about eligible employees? Under the Paid Medical Leave Act, there's a whole list of employees that aren't eligible, including part-time employees, including exempt employees under the Fair Labor Standard Act, including temporary employees who work for less than 25 weeks in a year. Under the Earned Sick Time Act, all employees except federal government employees are eligible for paid leave. Significant difference. How much leave? How much leave? Okay, under the Paid Medical Leave Act, I'll get them right eventually. The one we have now, the Paid Medical Sick Leave, you earn 1 hour of leave for every 35 hours work, capped at 40 hours in a year, or the employer can front load 40 hours and just give it to you and not worry about the accrual thing and call it good. And you don't have to let more than 40 hours carry over. And if you front load, you don't have to allow carryover at all. Under the Earned Sick Time Act, you get 1 hour of earned sick time for every 30 hours work, no front loading, nothing on carryover, no suggestion about capping other than the following. All right. How much leave do you get? Under the Paid Medical Leave Act, you get 40 hours in a year. All right? Under the Earned Sick Time Act, if you are a large employer, remember 10 or more employees, 72 paid hours per year. And if you are a small employer, it's 40 hours of paid earned sick time in a year and an additional 32 hours of unpaid sick time in a year. All right? Rate of use, 1 hour increments under the Paid Medical Leave Act. Rate of use, hourly increments or the smallest increment that an employer's payroll system allows to account for absences or use of other time. What about when can I use it? Well, the list there is significantly the same, basically the same. It's the same uses. But under the Earned Sick Time Act, you can also take time off for meetings at a child's school or place of care related to the child's health or disability or the effects of domestic violence or sexual assault on the child. Who can you take time off for? Well, you can take time off for a family member. We've got a list of what a family member is under the Paid Medical Leave Act. We all know what it is. Under the Earned Sick Time Act, we add the child of a domestic partner. We add a domestic partner. And we add the following category. Any other individual related by blood or affinity whose close association with the employee is equivalent to a family relationship. I have no idea what that means. And there's a number of other differences that we're bucking up on 20 minutes already, guys. So we just don't have time to cover here. So, keep an eye on your email. Keep an eye on your invites. We will be revisiting this. We will be keeping an eye on appeals. We will be keeping an eye on when Leo is going to start enforcing these provisions. And one other thing. No private right of action under the Paid Medical Leave Act. You have to go to LARA. There is a private right of action under the Earned Sick Time Act. You can sue your employer. So don't panic. If you've got any questions, give us a call. But keep your eyes out for e-alerts, for webinar invites, for other stuff that we may be doing. We're still trying to figure all this out. So stay with us, and we'll get back to you as quick as we can. And if you have any questions, give us a call.